Good afternoon, everyone. My name is Daryl Maxwell. I'm with the DC Bar Pro Bono Center. I would like to thank you all for joining this webinar. You are now attending the DC Bar Pro Bono Center's webinar, Intellectual Property Essentials, How Businesses and Entrepreneurs Can Identify, Protect, and Profit from Their Innovation. I would first like to thank Kelly Keller, an associate from Stern, Kessler, Goldstein & Fox, who has a practice in domestic and international trademark clearance, prosecution, enforcement, and portfolio management for clients in a wide variety of industries. Thanks again, Kelly. Kelly is a graduate of Penn State University and the Catholic University of America's Columbus School of Law. Let me also thank Marianne Lombardi, Chief Creative Economy Officer for the District of Columbia's Office of Cable TV, Film, Music, and Entertainment, for co-sponsoring this series. Before we get started, I'd like to go over some of the logistics for today's webinar. First, this webinar will be recorded. Additionally, there is a PDF copy of this PowerPoint presentation that you can download from the GoToWebinar dashboard. If you'd like to recommend the presentation to a friend, there will be a copy of this webinar on our resource site, www.lawhelp.org/dc/CED. For questions during the webinar, please use the question box in the dashboard on your computer. During the presentation, I will share those questions with our presenter. Intellectual property for an entrepreneur can be extremely tricky, whether at the start of your business or along its life cycle. I'm going to make sure to turn it over to Kelly Keller, who can go through the entire, or quite a bit, these are intellectual property sort of essentials, but she's going to go through quite a list of information that you should know about getting your business protected. Kelly, I'll turn it over to you.
Thank you, Daryl, and thank you to everybody for being on this webinar today and for giving us your time. I hope that you will find it valuable and useful and informative as you are either contemplating starting a business, or you've just started a business, or perhaps you already have been in business and you're ready to grow or to take it to the next level. So if you're in any of those places, then you are in any of those situations, then you're in the right place, and this webinar is for you. So let's get started. And let's see. There we go. Okay, thank you. So again, as Daryl said, I'm Kelly Keller, and I'm an intellectual property attorney. And today we're going to focus on intellectual property essentials. So that's essentially the sort of the bedrock, the core pieces, the things that you need to know. Essentially, it's like a glorified vocabulary lesson so that you understand exactly what we're talking when we talk about intellectual property, and can start to understand and envision how it matters to you and how it matters to your business. So let's start with the big picture at the conceptual level. What exactly is intellectual property? I mean, we hear that term, we get confused, and we think, I know, maybe something about ideas or patents, and it can be a complicated concept. So why don't we try to drill that down and make it a little bit simpler and comprehensive so that we can all get on the same page. So think about intellectual property essentially as creations of the mind. It's your imagination, it's your creativity, it's your ingenuity that collectively, when put together, they create something that actually has commercial or marketplace value, and for which the law recognizes your exclusive rights in it. So if we think about it as your creations of the mind that are commercially valuable, and the law is going to treat them almost like they would treat a piece of real property or personal property. And what I mean by real property is real estate, a house. You actually, when you buy a house, you get a deed to that house. You claim ownership of that house, and you have dominion and control over that property. Well, the same thing with a piece of personal property. That is something like a vehicle or a bike. It's your clothing, it's your computer, your equipment, your furniture. It's anything that isn't actually stuck to the ground like a house is. And the law says that it's yours. You possess it and you can keep other people from taking it. And if they take it from you, then the law says that you can punish them and they're required to give it back to you. Well, think about that analogy as the same thing for intellectual property. The law says that we're going to give you legal rights to keep it to yourself so that if somebody else takes it, then we're going to provide you with a legal remedy so that you aren't ultimately harmed by it. Intellectual property can be extremely valuable, and you do not have to be a mega corporation for it to be valuable. We think about these pharmaceutical companies, and they have, these proprietary drug formulations, and they make billions and billions of dollars, and we hear about these, major companies on the news. But intellectual property, I call it your superpower, and it matters to every single solitary business, whether you're a one-man band or you're a mega company. Let's think about how it's actually valuable. So let's think of intellectual property as intangible. It's not something that you can actually touch. So if you actually have an intellectual asset, so let's say that it is, it's your brand, it's your trademark. You can't touch it, but it's this thing, it's an intellectual property asset of your company that gives you a competitive advantage, something that makes you different in the marketplace. So it's not your actual products that you sell, it's not the widgets that you make, it's not the inventory on the shelves, and it's not the services you provide, but it's the brand name by which the customers recognize those products or services. Well, think about that. It's something that's intangible. It gives you competitive advantage. If you lose your rights in that, somebody steals it, they infringe it, or they actually try to go into business and compete with you by knocking off your trademark, then that could be very costly to you. It could cause you to lose your reputation. What if they were using your trademark for inferior products or services? Then people could start to get confused and think you're the shoddy company. This is how we think about this when we hear about counterfeits. When somebody creates a product and then they put a brand name on it that's not actually the real brand name, it's a fake, and if people get confused, they may start to think that the genuine products aren't very good, and it could diminish their reputation, and it could actually cause you to lose profits and ultimately lose your competitive advantage. So it can be as simple as a sole proprietor's brand or a huge company's drug formula. It matters to everybody, and it's extremely valuable. And so here's the big picture vocabulary lesson. When we think about intellectual property, we essentially categorize it into 4 buckets: trademarks, copyrights, patents, and trade secrets. We will look at these in more depth as the presentation continues. But I want to make sure that you understand that although there may be some overlap between these various buckets or categories of intellectual property, they are different and they serve different purposes and they're governed by different laws. So it's important that you understand what bucket your intellectual property falls in so that you're better able to protect it, to manage it, to understand it, and to work with it. Not every business will have intellectual property in all buckets, but every business has intellectual property in at least one of the buckets. Why is intellectual property important? Well, what you didn't know today was that you're going to get a small history lesson. Intellectual property is an enormous economic driver. We go back to the last slide, and what we talked about, or the 2 slides back, was that if you lose your trademark rights because somebody starts to use it without authorization, then it's going to hurt your business value and you could lose money. That's actually economic harm to you. Well, when you have one small business and then another small business and then another small business having economic harm, then you have a bunch of businesses who are going out of business, and that's harmful to the economy as a whole. So it actually matters at the most granular level. Well, the reason I have this interesting slide that has we the people, which is the first page of the United States Constitution is to help you understand just how important intellectual property is to economic growth in the United States. There's really only 3 ways that a nation can grow rich, and that's through natural resources. Think of oil. That's through cheap labor or inexpensive labor. So you think about massive, massive populations in places like China or India, where you have just an incredibly, incredibly large population to fill the labor pool. And then the last piece is if you don't have the cheap labor and you don't have the natural resources, then you're going to have to rely on the ingenuity of your people. Well, when America was founded, we didn't have the natural resources, and we didn't have the population to support the work. Therefore, we had to rely on the ingenuity of our people. So in the Constitution itself, before you even get to the Bill of Rights, so sort of stop break history lesson, the Constitution was ratified in 1787. The Bill of Rights, that gives you the freedom of speech, freedom of religion, right to bear arms, and so on and so forth, is in the Bill of Rights, which was ratified in 1791, some 4 years later. So before we even have the freedom of speech, in the Constitution, we have the only right that is granted to the American people, which is the right to profit from your respective writings and your discoveries. So essentially, the Constitution directs Congress to create a legal structure to recognize the intellectual property assets of the people, because that is how they knew that our country would be able to build a strong economy. And that is the foundation of what we proverbially call the American dream. Everybody knows that if I could just get to America, I could actually finally get rich. It's like the adage that every 2-year-old knows. If you build a better mousetrap, the world will beat a path to your door. And that's the essence of the American dream, and it is rooted not only in the nature and the character of American people, but also in the Constitution itself. So it's a really, really, really big deal, and that's why I call it your superpower. So now that we're on the same page, conceptually understanding we have these creations of our mind, they have commercial value, and the law recognizes them. Okay, so I have all of this, but how do I know, am I supposed to take action and actually protect it? So I've heard the concept of, do I need to file a trademark application? Do I need to file a patent application? What am I supposed to do, with a copyright? I created something. I'm a little bit confused. Well, I believe there's a 2-step test to determine if you should actually protect your intellectual property. So what the purpose of this at the very beginning of this presentation is to say, okay, I know you're just getting started, or if you're in that place where you're just getting started, you may have a very small budget, but you're full of innovation and ideas. Not everything has to be legally protected immediately. Only those things which are directly related to your competitive advantage and actually have marketplace value. So what do I mean by that? What are the things that give you a distinctive position in the marketplace? That's probably your brand. It makes you different from somebody else. Perhaps it's your way of doing business. Perhaps it's your business model. It's your customer service process. Maybe it's your unique customer list that you need to protect. Maybe it's your it's actually a recipe, and whatever that secret sauce that you're putting into that particular food item that just makes it want to fly off of the shelf, that's something that makes you different. But then in addition to that, the next step is, does it actually have value in the marketplace? And I call this the sentimental versus the commercial test. I can't tell you how many times that I have had an idea about something and I'm so excited about it. And I just think it's like the latest, greatest thing. And then I'm like, only my mom will buy it. Like, nobody wants it because it's just not commercially valuable. It's out of time, it's out of space, whatever it is. It just isn't what the market will bear. It's not what they're interested in at that time. So before you protect a piece of intellectual property, you want to make sure that it has commercial value or is likely to have commercial value. So you don't have to be afraid thinking that everything is going to have to cost a ton of money, but you can actually be strategic about it. And this is why it makes sense for businesses to start to build a brain trust very, very early in their development, where they have a team of professionals who are actually going to help them take this ride in the right way. Business ownership is a journey and it's a process, and you need expert help along the way. And having legal advice is one of those, or having a team of lawyers, whether it's just a business lawyer, it's an intellectual property lawyer, maybe it's just one lawyer at the very beginning who's going to help guide you and help manage your strategy so that you're doing the right thing at the right time to help you actually be able to profit from your own uniqueness, your distinction, and your creative genius. Okay, so let's get back to some of the more bedrock issues, and let's talk a little bit more detail about the 4 categories of intellectual property. Remember, we talked about patents, and we talked about trademarks, copyrights, and trade secrets. So we mentioned those general categories. So those are buckets of intellectual property. And remember, there may be some overlap, but they are different and they serve different purposes. So let's start with patents. When we mention patents, the first thing that probably enters into your mind is the idea of invention. And that's exactly what patents are. They are protections for inventions. Inventions are things that are functional. They're processes, they're things, they're machines, they're motors, they're electrical systems, they're chemical formulas. They are things that work. That's what's really important, so they're functional. So essentially what a patent is it's like a contract with the government. So the government, through the agency of the United States Patent and Trademark Office, will give an inventor a patent, which is essentially an agreement that says you can make, use, and sell your invention for a limited period of time, provided that you disclose everything about that invention, what it's made of, how to make it, everything that makes it work. And you put that in a patent application, and that in exchange, if we believe that it rises to the level of patentability and it meets all these requirements, then we're going to give you that exclusive right. It's essentially a monopoly to make, use, and sell that for a period of 20 years from the date that you file that application. And that is ultimately the heart of what was in the Constitution. It says, you know, we're rewarding you for your innovation and for your genius. But if you think about it, you know, if you're hanging out in your garage or you're hanging out in the lab and you have this amazing idea, well, it doesn't help the world. It doesn't benefit your community. It doesn't benefit your company. It doesn't benefit your country or anybody if you keep it all in your head. But if you disclose it and you start telling people about it, you want to be able to control it. And the only way that you can control it is by the government giving you the legal right to control it. So if we analogize back to that concept of property, it's like the car. If you have a car in your driveway and you have the key to it, you have possession of it, but it's really, really hard to control how, to control sort of moving it around, selling it or getting rid of it. It's very difficult to manage all of that if you don't have the title to it. So if you have the title, you can prove that you own it, you can prove when you bought it, you can prove all of the details. It's got an identification number on it, kind of like your own social security number with the vehicle identification number. So the patent is sort of the same thing. It's like the title to your invention. And that is incredibly valuable, so you can understand why that is so economically important. Okay, trademarks. And we'll go a little further into patents, so if I didn't answer your question, don't worry. We're kind of going in layers so that we start at the top and then we're going to kind of keep peeling this onion back. Okay, trademarks. Let's distinguish those from patents. Patents, we think inventions. Trademarks, immediately think brand. Well, ultimately, trademarks, they distinguish one manufacturer or one merchant's goods or services from another. So when we think about, okay, I want to go to a retail store, and you know that you want to go and you want to buy cleaning supplies, but you also want to get a new blender, and you want to get a new Keurig, but you also want to pick up some party supplies. So you think, okay, I'm going to go to Walmart or I'm going to go to Target. Essentially, the stores offer the same types of products. And if you're at a super Target, it has groceries too. So they have the same types of products and services in the retail environment. But what makes them different is the trademark. It's the name Walmart, it's the name Target, or it's also the actual design. So for Target, it would be that bullseye design. The mark itself, when you're driving down the highway and you see a sign and you see the trademark, you're going to know exactly what store that is, and you're going to have an idea of what you're going to be able to buy when you get there, and you're going to have an idea of what it's going to cost. And so if you see Target or you see Walmart, and let's say you see them in the same vicinity, you're going to make a decision, and that decision is made exclusively on the brand name and your perception of the brand and your understanding of what it means and what it offers. So trademarks essentially distinguish the source of particular products and services. Trademark rights are national rights, and what's interesting is unlike a patent that expires after 20 years, trademark rights can last forever so long as you're using them. So one of the oldest trademarks known is the mark Stella Artois for beer. It's been around for several hundred years. And you even think about some of the oldies, the goldies here in the United States. Let's take Coca-Cola, for example. You've had a brand that's been in business for more than 100 years. That's long past. That's long past 20 years from a particular patent. So you see that brands, so long as they're being used and they're still being used in association with products or services, they can last forever. So you can start to see how important a brand is, just how important it is, because it can last forever. And if it's damaged, it can cause an awful lot of harm, or you're going to have to work really, really hard to rebuild it. Think of a recent example in the news of Wells Fargo. They've had a lot of damage to their brand based on the banking scandal of fake bank accounts and some, misuse of consumer money and various issues. Although that's just one small division of a huge banking organization, it's impacted the entire brand, and they're working on a lot of corrective advertising and working to rebuild the trust in the people. Because when you see you hear the name Wells Fargo, if you're familiar with the business issues they've had, you may have never had an experience with that bank, but just based on the scuttlebutt, you may not have immediately a positive impression. So that's the power of branding. Okay, let's hit on copyright. What does a copyright do, and how is it different from a trademark, and how is it different from a patent? Copyrights protect original works of authorship. They must be fixed in a tangible medium. So what exactly does that mean? So if you think of yourself a creator as an author, that's the word we use. It doesn't mean just writing words, but you're an author of a creation. So that could be a photograph. It could be a painting. So a photographer is an author. A blogger is an author. A painter is an author for purposes of copyright law. So the moment you take something that's your creation of your mind and you create it in a tangible medium, meaning you actually put pen to paper, or you type words in a Word document and you save it so it's tangible, it's not just an idea in your head, or you actually snap a photograph, whether it's with your phone or with a more traditional camera, whatever that is, the moment that you fix that creative expression in a tangible medium, then the law recognizes your rights in it. But this is a good opportunity to raise the concept of ideas. the law does not protect ideas. It only protects the unique expression of those ideas. The law can't get into your head and say, okay, I'm going to give you protection for all these thoughts in that crazy space up there, because somebody else may have the same crazy thoughts as you, and you can't stop them from thinking up the same thing you're thinking of. So it's not until you actually put it in some type of a tangible expression that the law can attach some type of legal protection to it. And that's why we have this tangible medium requirement. Well, like a patent that gives you the exclusive right to make, use, or sell it, copyrights similarly, they give the author the exclusive right to reproduce it, like to copy it, or to distribute it, so that's like to sell it. If you think about, you know, a book, you can't make a photocopy of it without permission, and you can't go into the business of selling somebody's books. You can't, if you're a publisher, then you have the right to sell it, but if you're not the publisher, you can't just go start selling somebody else's books. Those rights are actually reserved to the author. And interestingly enough, copyrights, they're sort of a balance between patents that are 20 years from the date of the application. Trademarks can last forever, so long as they're in use. With copyrights, they actually last for the duration of the life of the author plus 70 years. So that's a really, really long time. In recent news, you've had issues with the copyright for John Steinbeck's book, The Grapes of Wrath. You've had copyright issues with Winnie the Pooh. And when these authors die, depending on when they die and what the law was in place, but sort of, let's say that, you know, these works are something that were created under this current law or something similar, you know, these rights are going to last for 70 years after they die, which means that their children and their children's children may actually be managing those rights. So you can think about how incredibly powerful that is. And this ties back nicely to this idea of protecting intellectual property that actually has commercial value. So if you think of somebody who's, you know, a mad novelist, and then they write something amazing, or let's say it's just, you know, Ernest Hemingway, Old Man and the Sea, or For Whom the Bell Tolls. These are some of the, you know, the classics that we read in school, that they ended up having tremendous commercial value. So the rights in those works are incredibly valuable because they last so long. But not just that, this is also a great opportunity to raise the issue of sort of the proliferation of a copyright. So if you have a book and you think about the rights in a particular book, for example, there's on television now, there's a series, and if any of you are familiar with it, it's called Outlander, and it is based on a series of novels. And right now, I believe there's like 9 books in the series, maybe there's more, but it's basically a time travel story where a nurse in the 20th century falls through time to the 18th century in Scotland, and it's, you know, sort of had like viral popularity, and the rights in those novels to be able to make a movie out of it or to be able to make any type of television program were purchased by a studio. So all of a sudden, the right to take that story and make a movie out of it, that is all based on the copyright. And so the author is not only earning the money on the sale of the books, but also on the making of the television series. So we can see just from one novel that has commercial value how incredibly powerful that can be. And the author is still living, so once she actually passes on, her family will be able to inherit that right and manage it for many, many years, several generations after her passing. So that's just the power of the copyright. Trade secrets.
Hey Kelly, can I jump in? I had a couple questions. I was trying to hold. Sure. You're done with the copyright section. So one of the questions, I think, I just was hoping you'd expand a little bit on derivative works. The other question was basically, what freedom do you have to use other people's ideas? Essentially, sort of what counts as someone else's idea, sort of in your own expression of said idea, and how to, you know, and what then creates infringement?
Sure, those are really good questions, and we're going to get a little deeper into copyrights in a couple of slides, and so I'll talk a little bit more about derivative rights there, if that's okay. And then with respect, that's an excellent question. And with respect to understanding infringements and ideas, I think it's simple and it's complex at the same time. Ideas are not protectable. Only the expression of those ideas are. And the expression of those ideas they have to rise to the level of being legally protectable. So unless they're legally protectable, they're free for other people to use. So let's take a perfect example of let's take an example of a brand name. And we're going to take the deeper dive here in just a couple of minutes on each of these areas. But for a brand name, for example, if your trademark is not actually able to be protected as a trademark, then anybody can use it. So for example, generic words cannot function as trademarks. So nobody can own the exclusive rights in the term chair. And nobody can own exclusive rights in the word medicine, for example, because these are generic terms. So if somebody else isn't capable of owning exclusive rights, then they can't keep you from using it. It's the same thing with a patent. If you have an invention, but it is not actually something that is patentable and that it rises to the level of patentability, it's unique enough, etc., and our next slide will get into that, then anybody can use it. Or if it's something that's in the public domain because the patent's already expired on it. And so this begs the question of how do you actually know that? And the way that you know whether something is available is generally by searching the record. So you would search to see whether something's available to use, whether it's already patented or not. You would search to see whether the trademark is actually legally available for you to use. The same thing with the Copyright Office. Or you can search to see whether somebody's actually claiming a copyright in something in particular. And then the same thing with trade secret information is whether or not something has actually been made public or not. So it really comes down to, and if you're not sure about something, then it can be as simple as just asking somebody, what is it? But a lot of times this is why having some legal help to help you determine not only whether you can protect something, but does somebody else already have ownership rights in it so that you make sure that you don't step on their toes. And that is where getting some legal advice and some strategic help would be, so you're approaching intellectual property from an offensive and a defensive position. Does that help answer that question?
Yeah, I think that works. Thank you.
Okay, perfect. So I'm going to just, so now we're peeling that onion, and now we're going to get into the to the bottom meat here. So hopefully we'll answer some more of your questions, but please feel free to keep them coming. It's a lot of information to cover, but important information. Okay, so patents, I just want to explain that there are essentially 4 types of patents that you can get. We look at, let's think about the bucket of patents, and let's look at sub-buckets. So a utility patent is something that it's kind of the obvious invention. It's a process like a computer, like computer software, or a printer, a machine, the mechanics that are inside. It could even be something as simple as a pencil. And think about, you have pencils and you have, the lead, and you have #2 formula that you always had to take your tests with when you were in school, and then you have mechanical pencils, and think about all the different innovative parts of a pencil. A composition of matter, so it's basically taking naturally occurring elements and putting them all together to create something unique, like a pill or a drug formulation. If anybody's ever had an IV and they've had a drug put into that syringe and then it goes right into their bloodstream, that is probably a unique technology, a pharmaceutical innovation to help combat whatever is ailing you. We also have design patents. And sometimes, like there's a picture right here of a Croc shoe. So design sometimes can be as important as the actual technology that's incorporated into something. And this is one of those areas where we kind of cross over a little bit into trademark law. Think about the Apple products. So you think about iPhones and you think about Macs, and you think about everything's white and everything is contained in one seamless box. So you don't have a lot of component pieces, so you can't actually open the iPhone and take it apart. That's part of its technology, that's part of its appeal, and it's part of its design. And it's designed to be aesthetically pleasing and to make, enhance the user experience, and that's also protectable. Covered business methods, these are a little bit of a controversial type of patent, but things like Amazon's one-click order, that's sort of a way of being able to do business. Those can also be patentable, as well as varieties of plants. And we hear about this a lot with genetically modified organisms, that companies actually have patents on plant varieties. And a lot of times, some of the genetically modified organisms are made so that they will actually be resistant to certain types of pesticides and things like that. That is obviously a very controversial area of industry as well. But essentially, patents break down into four pieces. They are four sub-buckets, rather. They're difficult to get. They're extremely expensive to get. So unless you are really, at the break point of an innovation or an invention, it's not always, it's not an immediate path to victory. However, if you think you have something that falls in these categories, it's extremely important to talk to a patent lawyer as soon as possible, because there's rules about the time that you need to file a patent application before you put it on sale, etc. So it's just important to be aware. It's kind of like know enough to know when to ask the question and know what you don't know. And so if we achieve the mission of helping you know what you don't know so that you get help and can actually understand if you have something that's potentially patentable, then hopefully you are getting enough of a vocabulary lesson here to be able to do that. We mentioned a little bit about, and the question, how do you know whether you're infringing somebody's patent or not? Well, for something to be patentable, it has to meet what we call, it has to be what's called patentable subject matter. That means it has to be something that's novel, it's unique, it's not been done before, it's useful. That means it's something that's functional. We talked about that earlier. And it's non-obvious. What that means is that somebody who's actually skilled in that art or in that particular technology, that they wouldn't be able to think it up without a lot of effort. So it's sort of like the duh test. Well, duh, that's so obvious. Anybody could have thought of that. Any 2-year-old could have thought of that. I mean, that's simplifying it, but that's the idea. So there's really a pretty high standard for whether something is sufficiently novel and sufficiently non-obvious to actually be patentable. And as we develop more and more and more technology, it becomes more and more competitive. But I'll tell you the other thing that's really, really interesting about patents and how it drives our system is this. You have an idea, you have an inventor who has that creation in their mind, right? And they actually want to make something, and they are convinced that when the government gives them a patent that it's worth them actually disclosing all that private information in their mind, so they're actually going to create something. So let's think about the idea of a chair. So I'm an inventor, and I have conceptualized the idea of this thing that I could actually sit in. And so it's going to have 4 legs, it's going to have a seat, and it's going to have a back to actually support me. So I have this conception, and I reduce it to practice. That means that I've actually created a prototype of it. It's something that's physical. Remember, the idea isn't protectable, that expression is. So in here, with regard to patents, it's that reduction to practice. Okay, so I've got a chair. So this means that I've actually got an invention, and I'm going to get a patent for that. And that means that I have the exclusive right to make it, to use it, and to sell it. Only I can do that. I don't have an affirmative duty to do that, but I can keep other people from doing that. So for those who are wondering about infringement, you want to make sure that if you have an invention that you want to start selling, that somebody else hasn't already done it before you, and you'd be infringing on them, and you do that through a patent search. But here's the cool thing about patents. This is it's simplified, but I think it illustrates the point. I've created this chair, and we can all envision a wooden chair, 4 legs, chair, and a back. We all went to school on them. Okay, but Daryl decides that he's an inventor as well. And so he's conceptualized an idea to improve on what I've made. And he says, I really think what Kelly created is pretty cool, but I would like to have it be movable. It's kind of tough if I actually want to, scoot myself forward or back. So I'm going to put it on wheels. And it's not really all that comfortable. So I'm going to put an interesting type of cushion, and I want the back to be flexible so that when I'm thinking, I can push back into the chair and I can kind of have a little bit of a rocking motion. So I'm going to improve on it. So my improvements are their own unique, novel, and non-obvious inventions. So I'm going to get a patent on all of my improvements. So when I manufacture and I sell my chairs, I'm actually going to have to pay Kelly for the rights to use her technology in my technology in my chair. I'm going to have to use what she owns to create my chair, but then I'm going to put my improvement on it and I'm going to sell it. So then Inventor 3 comes along and they decide they want to improve it from there. So you can start to see how the wheels of innovation go and how the patent system works and why it's so incredibly important. So hopefully that illustrates for you how patents work and why they're so important and how the ingeniousness of the system is, because remember, in that patent application, you're disclosing the best way to make it, best materials to use, all the measurements that you need, and if there's any type of a dash of this and a glob of that and an inch of that and a yard of that, you're going to have to disclose all of that information in the patent application, which means that once the patent's granted and other people can read it, they can start innovating beyond you so that we're not actually waiting 20 years before the next generation of a particular product comes. You've seen this in computing technology. That's how we've been able to evolve so quickly. So let's move on and let's get down a little deeper into the trademark onion. You've seen the little TM and you've seen that little SM to the right of trademarks or names all over the place. And a lot of times, and you've also seen the circle R. Well, a lot of times it's very confusing. These are called trademark symbols. And the trademark symbol simply means this. For trademark, it means, or TM means trademark and SM means service mark. What that means is that the TM is used when the trademark itself is the brand name for products or goods, such as shoes or clothing or cars. The service mark is when the product is for a service, such as like telecommunication services like AT&T or Verizon or Sprint or restaurant services. So for Panera or Red Lobster. So you can use them interchangeably. We'll get in a lot more into trademarks into the second half on the second portion of this webinar series in a few weeks, but I wanted to give you that high-level overview. It's okay to use a TM on a service mark, but some people choose to be a little bit more exact. Less common types of trademarks are what we call membership marks and certification marks. You've often heard, for example, if you've ever purchased a home, somebody say, well, I'm a member of the realtor organization. That means that I'm a member of this particular organization. That means that I have certain creds and that you can trust that I've been trained in a certain way, so on and so forth, or that I'm associated and have the backing of this organization. The same thing, for example, like with Teamsters for union membership. Certification marks are when you're able to use something like certified USDA organic on food items. That means when you buy it, you know that it means certain quality standards. A really common one is the Good Housekeeping Seal of Approval, for example. Bam! You see that and you know, you may not know the details of what that means, but you know that somebody has certified that that product does what it says it's going to do. And if it doesn't, good housekeeping standing behind it. So generally, unless you're offering a certification program, like you're actually training people in a certain way of doing something, these aren't going to be relevant to your initial business, but it's important for you to understand them from a vocabulary perspective. So what are some of the most common trademark types? Words, Coca-Cola, McDonald's, AT&T. Symbols, You know exactly what those are. Apple, Nike, Olympic rings, a combination of words or symbols, or even a slogan. Just do it. What's in your wallet? Chase the rainbow. These are your most common types of trademarks. Interestingly, your less common types of trademarks: colors, shapes, sounds, and scents. In fact, Play-Doh recently filed a trademark application to receive exclusive rights in the smell of its actual Play-Doh. I don't know if kids play with Play-Doh anymore, but that was sort of a fun fact on those of us in the biz. But when you see like a UPS car driving down the street and it's big, big brown truck, you won't see any other brown trucks for shipping services because UPS owns exclusive rights in the color brown for shipping services. So you can see the trademark rights are very, very broad. They're deep and then they're wide. Okay, here's a key point on the trademarks for those of you who are just starting businesses or have started them and are thinking about how to name your business and how to name your products. And again, we'll take a deeper dive in the second half of this webinar, but here's your overview. Trademarks and trade names. Trade names are the legal name of your business. So if you formed a company with the District of Columbia, you got an LLC or you got a corporation, you had to name it. And the District of Columbia had to approve your name. And essentially what they're saying is there isn't any other business with that exact name in the District of Columbia, so I'm going to give you that name. It is, and they only care about it in the District of Columbia because business names are regulated at the state level. So you could have, if I am ABC Company in the District of Columbia, there can be 50 other ABC companies, one in every other state, because we only care about what's in that particular state. It doesn't matter if there's, if the ABC company is in DC, it doesn't matter. Nobody in Pennsylvania cares about that and vice versa. A trademark, on the other hand, it's not it may or may not be the legal name of your business, but it's what is the brand name for your products or your services. So let's think about a perfect example here, which is everybody's heard of Tylenol, but most people have no idea that it's manufactured by McNeil Consumer Products Company. And McNeil Consumer Products could sell itself, it could be bought out, acquired 15,000 times, and nobody would care so long as they can get their Tylenol. Because that's the difference between the brand name and the actual business name, but sometimes they actually match. So you have Nike as the brand name, but it's also the business name. Well, let me go back one slide. Oh, excuse me. Sorry. Technical glitch. But to go back, when I mentioned the trademarks and the trade names, what's important is if we think about Nike, for example, you can have a Nike Inc. in DC, you could have a Nike Inc. in Pennsylvania, and you could have a Nike in Virginia. But let's say in DC, for example, if you have Nike Inc., and that's actually the business name of the real Nike, but then somebody wants to come along and call themselves Nike Apparel, and DC says, okay, well, I don't have any other business name named Nike Apparel, then they're actually going to allow you to use that as a business name. But if you tried to use that as your brand name and as your trademark and hang out your shingle, whether it's a proverbial shingle or it's an online shingle on a website, then Nike's going to have something to say about it because now you're infringing on their brand name. So it's extremely important to understand the difference between a business name and a brand name. And that's one of the most important decisions that you will make very early on in your business. One of the questions that we were asked about was actually protectability of, how do you know whether somebody can, if you're infringing on somebody else's mark? Well, we'll kind of run through this quickly because we have another hour on trademarks here in a couple of weeks. But trademarks can only be protected if they are capable of distinguishing the products or services. What that means is that when somebody sees the name of actually comes and encounters a mark, that they can understand that that is the source of a unique product or service. So for example, Target, that is the name, and that is the brand name for retail services. But if they wanted to call themselves retail store, that doesn't distinguish the products or services from any other retail store, so the name isn't sufficiently unique. So only names that are sufficiently unique can actually be protected. Trademarks.
Hey, Kelly, can I
Yep.
jump in with two questions?
Yep.
The first question is, so does changing the font of a logo, if the shape and style doesn't change of the trademark, does that does that require you to then file like an amended or a new filing?
So you're changing your own trademark.
Yeah, you're changing the font, but essentially most of it stays the same.
It depends on how you filed the trademark the first time. If you filed the trademark application the first time using what's called standard characters, that means that you just filed for the word itself, then that registration allows you to have flexibility with the font, the stylization, and the color, and you would not need to refile. However, if you're looking for the registration to extend specifically to that font and to that stylization, then you would need to file a second application. You cannot amend an application once it's filed. So your basic application's in standard characters, so you can use, it's essentially protecting the word irrespective of the color, font, or stylization. Mm-hmm. Coca-Cola is a great example. So the script for Coca-Cola is as big of a deal and is as important as the words themselves. So they actually have trademark registrations that are specific to the script as well as the words themselves. That's a great question.
Okay, and then I've got one more.
Mm-hmm. Go ahead.
So I've got one more. And I know we have a lot of creatives who are interested in who are on the line. If you're writing a response to a book, or you want to make a response to a book or a related workbook or product, is that the type of thing that is allowed? I'm going to assume that's a copyright question. Go ahead.
What do you mean by a response?
I think it sounds to me from the question, if you're citing the book as sort of you're citing the book that you've read or you're responding to, and then you're writing it's a different idea, but it's in response. And I've seen this in articles, but I've not seen a full book response to another book. But I think they're trying to figure out if that's it sounds like it would be allowed, but I posed the question to you, inartfully, but I posed the question to you.
Sure. Well, I'm going to answer that. Let me answer it this way. Is when you write something, as long as it is an original work of authorship, it is not borrowing from somebody else's words. You're not actually lifting their words. As long as it's original to you, then it's an independent creation. So if you're writing a response, remember the idea isn't protectable. The idea of the initial book to which you're responding isn't protectable. What you can't do is actually lift their text, unless you're actually lifting the text for purposes of saying, this is what they said, here's what I'm saying. And when you do that, you're actually giving proper attribution, and you're quoting it so that people understand it's not something that you're claiming right then, but you're just simply comparing to that. So as long as your creation is independent and it's not an actual copy or just a tweaking of their work so it looks like it's a copy, but it's actually something independent, even though the ideas are similar or related, it would still be independent and yours. Does that make sense? Did I answer the question?
You did, yes. Thank you very much.
Okay. Well, what I'm going to do here is, since we have another hour on trademarks, is I'm going to jump right into, and we can finish the rest of the time here on copyright. And so pardon me as I move forward through this slide relatively quickly. And so hopefully this will help, and then I'm happy to stay on the line and answer questions for as long as anybody would like. Okay, so all of you creatives out there, what a wonderful group, an amazing bunch of people. You help make the world go round. So copyrights protect your expression. And so what they do is they take your creative ideas and you've expressed them, whether it's in a writing, it's in a photograph, it's in a design, whatever it is. And it says that we're going to give you exclusive rights in it, so long as it's independently created, meaning it wasn't copied by somebody else, or you didn't copy somebody else. It has a basic level of creativity, and, you know, and it's original in the sense that when I say a basic level of creativity, you can't copyright facts. You can't copyright the phone book, for example. But ironically, there's a big Supreme Court case you can copyright. You can copyright the yellow pages because the sort of the design and the placement of the information is something that's been curated. The facts themselves, the names and the telephone numbers aren't necessarily copyrightable, but the sort of the full expression of that is, if that makes sense. So you kind of think of it as maybe you take somebody else's photographs and you create a collage. It's the collage and the placement of those images that's the unique element to you, but not the copyrighted material themselves. Here's what the copyright gives you, and you can think of this from an offensive and a defensive perspective. A copyright gives you a bundle of rights. It's the right to reproduce it or copy it, the right to prepare derivative works, the right to distribute it, make public performances, or a public display. So what that means, reproduction, copy, that's pretty self-explanatory. Distribute, that's to sort of make it available, to sell, to send it along, to email it, whatever that is. And I'm saving derivative works for last so that we can spend the most time on that. Public performances, that's something that's very simple. It's like a play, or it's even, that's the most common is a play. It's a concert. It's even the the mime in the park, or it's the guy playing the guitar in the park bench, hoping that you'll come by and give him a tip. That's a public performance of a musical work. Public display would be something like a museum, the right to hang a photograph in a museum. Preparation of a derivative work, and what that means is that you have the exclusive right as the copyright owner to control who can actually prepare the derivative work. So if you have written a book and somebody wants to write a screenplay based on your book, you have the right to control that. They can't do it without your permission, and the converse is true. You can't do that to somebody else's work without their permission. So if you're taking a work and you're taking the same essence of something that was created and you're transforming it into something new and different, but it is wholly reliant on that original work, that transformation still belongs to you as the copyright owner unless you've given somebody else permission to do it. That's the power of the copyright. That's the book to the script, to the screenplay, to the merchandising, et cetera, et cetera. That's how that works. So if somebody wants to make a derivative work, they have to get your permission. If you want to make a derivative work, you have to get the copyright owner's permission. Does that speak to the heart of what the questions were?
Yeah, for sure. Well, particularly on the derivative works, yeah.
Okay, perfect. And then let me wrap up with this point. Everybody understands the concept that as soon as you create something, copyright is an automatic right. So it's an automatic right upon fixation in intangible media. So I created it, I own the copyright. That is true, and under the current law, which was passed in 1978, it basically says you don't have to file anything, you don't have to do anything. You don't even have to use the Circle C copyright notice to own the legal right in it. But in order to enforce your rights in it, you must file a federal application for copyright with the Library of Congress, or the U.S. Copyright Office, which is part of the Library of Congress. Without a copyright registration, you cannot sue in court. Therefore, if you actually think of it back to the analogy of the title to the car, if you want to enforce your rights in something, and you want to stop people from being able to use it, and you want your efforts to stop them to have any teeth, then you want to register that work. Not everything that you create is worth filing a lawsuit over. So you don't need to file an application for everything that you create. But for those things that are a part of your competitive advantage and that have commercial value, those are the things you're going to want to federally register, because it gives you a lot of rights that you do not have under what we call a common law or an unregistered right. So the answer is yes, you own the copyright, but without a registration, it's very difficult to enforce. And if you write a letter to them and tell them to stop using your work, and that person takes it to a lawyer who understands that, then that could be strategically harmful to you. Most things in the workaday world, if you say, could you stop using that, people say, I'm sorry, I didn't realize it. But when you have something that's really important, you need to make sure that you have a legal strategy around it, because copyright registration is the key to being able to enforce. It doesn't necessarily mean you have to sue, but the fact that you can serves a great deterrent effect. So I know that we are, I know that we've come to our hour, and I only have just, if I could take about 30 seconds to wrap up this piece, and then I'm happy to stay on the line for any questions. I'll do that if that's okay. The last thing I just want to touch on is trade secrets, because as a new business, you may not think that you have a trade secret like the Coca-Cola formula or the WD-40 formula or something super secret, but you may have a lot of information that's important to you as you're developing your business, whether it's the type of customers that you have, it's your process, it may be the way you go about bringing things to market, etc. If you have a team of people who work with you and you don't want them to take your ideas and go into competition with you, and you think that that information is actually protectable, you know, like it's really important that keeping it confidential is part of your competitive advantage, then you want to make sure you protect that, and you should do that with contracts like non-disclosure agreements and things like that, because that's actually helping to protect the business secrets that you have. Contracts aren't meant to be mean. They're meant to be they're meant to show respect for the relationship. Good fences make good neighbors, and says, you know, I respect you and I want you to respect me. So a lot of times they're scary for small businesses, but for those of us, we're deeply, deeply passionate about the work that we do, and we want to share it because there's power in the sharing. But if we share it and we share it irresponsibly, then it's sort of like you snoozed, you lose. You didn't do your duty, so the law is not necessarily going to help you. So not to end on a doom and gloom, but it's just a note of caution that it is a tool that you have available to you to essentially say, let's just work within a certain set of boundaries so that this can be potentially an excellent business relationship as well as just a creative sharing relationship. So with that, we'll conclude our first part of this two-part webinar series with this very big, broad overview of the various types of intellectual property, its buckets and its sub-buckets, and look forward to the next session when we really go into a lot about trademarks, if that's still what is useful to the audience.
Yeah, and thank you, Kelly. And we do have a couple of questions, and hopefully our wonderful audience will indulge us a little bit. One of the questions is, I believe one of the entrepreneurs has, they've received a notice of allowance from the Patent and Trademark Office for their trademark application, and they're being asked about evidence for the mark being used in commerce. I think I know the answer to this, but what would that look like?
Sure. Well, it depends on if it's for products or for services. I don't know if we know the answer to that, but let's just assume that it's for products, so that you're actually selling. Let's say that the trademark is for coffee cups. Then what they're going to want to see is that the trademark itself is used on the product packaging or on the product itself. Like if you have if you go and you buy a coffee cup from Starbucks and you turn it upside down, you're going to see the Starbucks logo on the bottom. So what they're saying is, we would like to make sure that we see the mark used on the product itself or on the packaging for the product, so that consumers can associate the mark with the product. You know what the brand is. Or if it's a t-shirt, then you want to see actually the name of the trademark on the tag, even if it's, you know, the little tag that's got a plastic tie on it, that we need to associate the mark with the product. If it's for services, let's say that you're offering online coaching services, then we need to see the trademark on the website in association with sort of the page that lists the services and also shows people how they can order or purchase those services. So they need to see an association of the mark, the goods or services listed in the application in a way that people can actually buy them and purchase them. That's what in commerce means. So it's not just advertising that it might be available one day, but it's actually showing that as a customer, I could go on and I could actually buy that service today if I wanted to. That's what they're looking for.
Great, great. Let's see, I think we could probably fit in two more. I've got one, it's, I think basically the entrepreneur is looking at a design that's similar to the I Love New York image and looking to sort of reproduce it. And I think they're trying to figure out, would they have to copyright it like for every, like let's say they want to do I Love DC and I Love Austin, Texas. Would they have to try to, I think copyright's the wrong term, but would they have to try to protect it for every city, or could they get something that was a little bit more general, or could they at all?
Well, and that's a great question. I think it's important to realize that unless it's actually being used as a source identifying function, then it's not protectable by intellectual property. So you can't own Austin, DC, Houston, New York, San Francisco. You can't own the name of a city. And common shapes and symbols like hearts or boxes or diamonds or stars, those aren't protectable either because they're just common and that anybody in the public can, they're not sufficiently original. So unless you're actually taking that and you're creating some type of a unique design element with it, then simply I Heart and the name of the city would not be sufficiently original, in my opinion, to be protectable unless it became like the name, like a brand name. For example, Life is Good. Life is Good is now a brand name for T-shirts and car accessories put over the back of the wheel, that type of thing, because it actually has a source identifying function as opposed to a simple expression of a sentiment on a shirt.
Okay. Okay. And then let's just sneak in this last one. The example is if you were if you're working for a professor, you do most of the groundwork for their book, for instance. Or you do it and they take all the credit and you don't get sort of a note or a credit. Like, are there any rights to protect you? I feel like I already know the answer to this, but you're the expert. So.
Well, the practical answer is no.
Right.
And I think that it's and there may be some case law on this that I would need to look into specifically, but essentially. It's rude and that's disrespectful for the professor not to credit the people who are supporting them. But I think generally, unless the ideas and what you are contributing to their work is actually the independent and unique creation of you and not of them. So are you actually functioning just as a sort of a workhorse for them where you're actually just helping to flesh out their ideas or you're actually doing research, etc.? It's a question of who's actually the author. And that's really what it boils down to. Who's the legal author of the work? Are you the legal author or are they the legal author? And in most of those cases, the way it works is that the professor is still the legal author and you are supporting them under a contract to actually support that work. So I don't know, a lot of that would come down to what the agreement with the university is and so on and so forth. But as a general rule, if you're looking, unless you have an agreement with the professor that what you're doing is your own independent work and they're supervising you, but rather you're serving as a research assistant to them, if you feel like you're getting to the point where you're contributing a whole lot more than they are and you're starting to do something independent, that's probably a good time to stop and discuss the situation or move on to a new project. I think it's a very difficult, from a realistic perspective, it'd be very difficult to prove where their rights then and your rights begin.
Well, thank you very much for that. I think we've come to the end of our time, so let me first say thank you, Kelly, so much for giving us all this fantastic information. I will also say thank you to our audience for sticking around, and you can feel free to virtually applaud Kelly if you'd like. What we will be doing after this webinar is over, we will be sending out a survey to all of you to get your thoughts and any topics or anything else that you'd like us to talk about maybe in the next webinar, or if, as we move along, maybe think about doing something in the future. Let me also say that our next webinar, Trademarks, Costs, and Timelines, will be held on Wednesday, December 13th at noon. We'll make sure to email you as well. Like I said before, if you'd like to share this with your friends, the webinar has been recorded and will be up on our resource site, www.lawhelp.org/DC/CED. Thanks again to Stern Kessler for allowing Kelly to participate. Thanks to DC's Office of Cable, TV, Film, Music, and Entertainment, as well as the 202 Creates program for partnering with us. Look forward to seeing you all soon. Thank you very much. Have a good day.